This conference will now be recorded.
The live stream has begun.
Great. Thank you, Tessie. We are now joined by representatives from the Federation of State Medical Boards. FSMB conducted an audit of our board over the last several months and used the information to produce a report. We thank them for their dedicated work and insight. And I would also mention personally, it's a pleasure to see you all again. Our Executive Director, Stephanie Luca, will now lead us through the report, please.
Great. Thanks so much. Thank you all for being here. I think what would probably be helpful for our board members is to do a quick introduction of each of the FSMB members that we have on with us today. And then we're going to turn it over to three of the team members who will give us a high-level overview of the different parts that they sort of tackled and led in the report. And then really, I think we want to spend the majority of our time on taking questions from our board members and really taking advantage of the gracious time that FSMB has given us to do follow-up questions on the report. So why don't I'm going to go in order of the members that I see on my screen, and I'll just maybe call on each of you, and you can do just a quick introduction of yourselves. And Dr. King, I'm going to start with you.
Okay, thank you, Stephanie, and thank you to the Ohio State Board for having us here today to review the report. I will say, I think I've mentioned this to other people, I am an Ohioan, so it's good to be a part of this meeting and kind of return to my roots, so to speak. So I am currently in Burlington, Vermont. I live in Burlington, where I am on the faculty at the medical school and also on the medical group practice in internal medicine primary care. I had the opportunity to spend 12 years serving on the Vermont Board of Medical Practice, and also that included 4 years as the Vermont Board Chair. And then from that position, I had the opportunity to serve on the Federation of State Medical Board of Directors, and I also served as chair and just rotated off that board last year, having completed my year as immediate post chair. I think appropriate or especially applicable to this review, I chaired the work group on physician sexual misconduct when I was the board chair. That went for 2 years. We spent 2 years. Dr. Schottenstein was on our committee also, and concluded in the report that was adopted by the House of Delegates this past April, or actually May. It was the very first day of May or second day of May. We are certainly not through with that topic. We continue to work on all of the recommendations that we had in that report, and really look forward to advancing our knowledge and our best practice in this really important area. So again, I thank all of you. I thank you for your time, for your dedication to your own board. I really thank you for the opportunity we had to take a glimpse into your world, and we hope that you'll benefit from the report and that we have a good discussion today. So I will, Stephanie, thank you, and I'll turn it over to the next person.
Thanks, Dr. King. How about you, Kathleen?
Good afternoon. My name is Kathleen Haley, and I served as the executive director of the Oregon Medical Board for 24 years. During that time, I had 2 terms of service on the Federation Board of Directors, and I've had the opportunity to do 4 other reviews of other boards, including one in Abu Dhabi, which was an unusual experience, very different from the U.S. medical boards. And I am now serving on the Foundation for the Federation of State Medical Boards Board of Directors. I look forward to our discussion this afternoon, and thank you very much for this opportunity.
Great. Thanks, Kathleen. All right, Brian.
Hey, I'm Brian Blankenship. I'm the Deputy General Counsel for the North Carolina Medical Board, and I've been here for about 18 years, and thanks for the opportunity to speak with you today.
Thanks, Brian. All right, and then we have some FSMB staff as well. So I'll start with you, Mark, while we have you on camera. How's that?
Sounds good. Thanks very much. So it's a pleasure to be here. My name is Mark Stas, and I work with the Federation in the area of mainly policy development, also continuing education, and had the pleasure of being staff support for the work group on physician sexual misconduct that Dr. King mentioned. My role for this review was to provide support to our review team and to co-manage the process with another colleague who's on the line today. So again, looking forward to the discussion today. Thanks very much.
Great. That's a good segue to turn it over to John for an introduction.
Hi, everyone. My name is John Bremer. I am the Director of State Legislation and Policy at the Federation, where I've been for about 5.5 years. Within this project, myself and Mark co-manage this, and we're looking forward to the discussion today.
Great. All right, Michelle.
Good afternoon. My name is Michelle Turner, and I work in our IT department. I have had the pleasure to assist this team in lean and process review and enhancement. And thank you all for the time that you have taken to put into this. And I'm very excited to visit with you.
Awesome. Great. Thanks, Michelle. And certainly, last but not least, Christine.
Hi, my name is Christine Wells. I'm also part of the IT department. I'm an IT manager responsible for project management, software solutions, and implementation.
Great, thanks. All right, so next, I think, Tessie, if we could please put up the slide on the presentation overview that we have. And we're going to be talking about 3 major categories today. Communication, which we'll have Brian lead us through. Staffing, which Kathleen will talk us through, and then board involvement that Dr. King will walk us through. So we'll put up that slide, and then we'll turn it over to the 3 of you. And then after all 3 have been able to sort of introduce their topic, then we're just going to open it up to board member conversation and questions in general. So we're getting there.
There you go. Can you see okay?
Next, I think if we scroll down 1, we just have the intro there, but then if we, maybe the next slide there. Oops, next one, I'm sorry. Perfect. That's great. And then we can take this down after, once we move into the question and answer session. So I'll turn it over to you, maybe, Brian.
Great. Thank you very much. And thank you again for giving me a few minutes to speak with you today. It's really been a pleasure to serve on this review team and meet with your staff and talk to several of the board members. I've personally participated in several assessments of various organizations, and I've been on the receiving end of assessments. And I know these can be difficult, but I also believe that they are necessary for improvement. I want to commend you for requesting this assessment and for everyone's cooperation throughout the process. It was very clear to the review team that you're committed to honest self-reflection and improvement, and we really appreciate everyone's honesty and being open-minded during the discussion. You're fortunate to have such qualified members and such a dedicated and experienced staff. We all agreed that you made a great hire in Stephanie, who is committed to making concrete changes to improve the board. And she's made great strides to improve communication and the culture of the board. You'll see throughout the report that communication is a central theme, and we discussed and made recommendations for improved communication internally among staff, between staff and board members, and improved communication with your licensees and complainants. You'll notice on the side it mentions removing silos, and that's a word you may have seen several times in our report. And for those of you who may not be familiar with that term, in organizations, the silo effect often occurs when separate departments or teams within an organization don't have a system to communicate effectively, and productivity suffers because of it. Other causes of the silo effect can be a lack of understanding as to how a particular department fits within the bigger picture, causing the leader in charge of the team to focus on team goals versus organizational goals. And you get either teams or individuals who focus more on immediate results rather than larger organizational goals. In my experience, the silo effect is present in organizations that are hierarchical with sharply defined roles, long reporting lines, meaning many intermediary layers of management, and staff spread among several locations where there's little chance to interact on a regular basis with other departments. And based on my work with state and federal government agencies in particular really have to work hard to combat the silo effect. And the silo effect can really be dangerous because each department focuses on its own primary objectives. Departments don't communicate sufficiently or effectively. Departments don't cooperate with each other because they're uninformed. The lack of cooperation breeds resentment. Department members can feel isolated from other departments. And again, each department can focus on its own primary objectives. So with that as context and as background, we made several recommendations that we believe will improve communication and help break down the silos. First, we're a fan of your team-based approach that's used in sexual misconduct cases, and we believe that team-based approach holds real promise for improving communication. We found that except for sexual misconduct cases, the most common cross-department communication occurs at the top of the organizational structure. The silo effect and silo structure was also evident in the handoff from cases from one department to another. For example, as we were talking to staff members, we learned that once an investigation is complete and how the case is involved. So we think the team-based approach will create greater opportunities for communication, greater staff ownership of cases, and an increased sense of ownership among staff in the board. We also recommended a good case management software tailored to the needs of your board. My experience with a good case management software is it helps improve process flow, helps cross-team collaboration, helps with workload and resource management. It can provide alerts and notifications that really, again, help with resource management and collaboration. And there's just increased opportunities for communication and visibility. And I'll be happy to talk about that some more. We also made several recommendations regarding improved communication with licensees and complainants. Regarding licensees, we heard varying degrees of communication exist between the board and licensees during the complaint process. And we think it's important that the board communicate with licensees at the beginning of a complaint or investigation, and then at the end when the investigation is completed or closed. We also made several recommendations regarding increased communication with complainants or victims. I know from my work, it's very important and can be very frustrating to complainants and victims if they are not kept routinely involved, and often months can go by if we're not careful between a witness interview and any sort of follow-up. So we believe that increased communication and providing a more fulsome explanation when a case is resolved will help with that communication. So at this time, I'm going to turn it over to Kathleen. Thank you again for allowing me a few minutes. Thank you for allowing me the opportunity to participate as part of this review team, and I look forward to your questions.
Good afternoon again, and thank you for the opportunity to present some of the findings from our review. I had the opportunity to sit in on your board meeting, not this one, but the one before, and it's clear that you are a very committed body and you're focused on being the best board possible. You're also fortunate to have a very committed staff and, importantly, a knowledgeable and respected executive director in Stephanie. I'm going to focus my remarks on your staff and their roles. First, the investigators. They really need to be involved beyond just the beginning of the case, because that will ensure that they get appropriate feedback and they can make improvements. In my experience, both in Oregon as well as the other reviews I've completed for other boards, it's important to have those who gather the facts be involved throughout the case. It will enable them to understand what's expected of them by staff and the board and ensure greater consistency. We recommend participation by the investigators in the rounds and integration throughout the whole case. When I was hired at the Oregon Medical Board, there was a part-time medical director. I increased that position to full-time, and I also had a backup so that that medical director could take vacations periodically. The medical director provides the in-house medical expertise. The position also communicates to the medical community that one of its own licensees is available and has the background and experience on which to formulate opinions about cases, policy issues, and also new initiatives. Another benefit to having a medical director on staff is the ability to attract and retain expert reviewers. And in fact, having a medical director may result in having to farm out fewer cases for those reviews because those cases could be covered by the medical director. Triaging of complaints is an essential function of the agency, and it's also the primary way in which the public interacts with the board. Therefore, we looked at it as a critical function. When we urge you to develop some guidance and standardization of that process. In addition, there needs to be some timelines for those cases to be completed in the triage process, and perhaps shifting the function to administrative staff will free up some of the staff who are spending their time doing triage now. We believe that the triage team should report to the chief investigative officer, and if there are some thorny questions or questions that arise, they could be referred to a multi-department group. In my experience, a medical board is always engaged in a balancing act, and you want to get that balance right. With a focus on patient safety, there has to be sufficient resources dedicated to what I called the medicine part of the equation. When too much emphasis is on the legal matters, it can tip that balance off center. From our review, it appears you have tasks such as triage being performed by attorneys. An examination of the number of attorneys and the reporting is in order. Could some of the tasks that are currently being performed by attorneys be done by a different staff person, as suggested in triaging, or by a different department? With the current siloed approach that Brian mentioned, that emphasizes the legal aspects of your work, and there's real worry that you can get those cases jammed up or even lost. And that isn't due to ill intent or malfeasance. It's essential that the processes themselves be broken up into smaller tasks with milestones that the progress can be shared with everyone. When I served as the executive director in Oregon, I sat down with the investigative team and we talked about those thorny cases or the ones that were taking too long. And we used it as an opportunity to learn and help one another complete the cases more expeditiously. Having deadlines and attorney reports will help the board to go forward. One of the surprising findings of our review was the number of cases that go to hearing. Again, this is a time-consuming legal process. If enforcement attorneys in the Attorney General's office could settle more cases, it would benefit the public and your licensees. In Oregon, I worked under two models with hearing examiners. Initially, I appointed those hearing examiners. This was later changed to a pool of administrative law judges, with the board having the ability to reject a hearing examiner. We recommend that you consider a contract model for the hearing officer position, and this would give the executive director the ability to set and ensure expectations and timelines, as well as the performance of the hearing examiner. Finally, once a case has been completed and a licensee has been placed on probation or monitoring, it's essential that a compliance officer monitor that follow-through. The position could make office visits, interview appropriate staff, and perhaps gather charts for review by the medical director. Again, I thank you for your service to the Ohio Board, to the citizens of Ohio. You serve a very important function. and I'll be happy to answer questions at the end of Dr. King's presentation.
Thank you, Kathleen.
Thank you, Stephanie. And again, I would also like to echo the comments that Brian and Kathleen have made. We have gained a lot of understanding and have really appreciated your time. I sat in on part of your board meeting in August, and also, as Kathleen said, really saw your dedication to the state of Ohio and public protection and the state board. So I really thank you for all of the work that you do on behalf of the public and Ohio. So I'm going to talk a little bit about board involvement and to give you somewhat of an overview of our ultimate goals in board involvement. We're really looking to optimize the use of the expertise of each of you. And we're really looking to deepen your perspective of complaints as well as misconduct, to really deepen your knowledge of the cases and also of board function. And ideally, I think we feel that in doing so, that you will ultimately develop a better understanding of the spectrum of misconduct, develop a better understanding of the spectrum of complaints that the public brings, including the public perception of the board and its function, which is really critical for serving in your roles and for public protection. And then ultimately, also a better understanding of the function of the state board. I'll spend some time on that. And then I also want to spend some time on the public voice. I mean, we feel, and it's really become best practice, not just on medical boards, but on all boards now, that the public voice is very important. And I think when you're trying to protect the public, there's no better place for the public to be present than on state medical boards. So I'll spend a little bit of time talking about the public voice, and along with that, the value of diversity and the voice of diversity on state boards. I don't think I have to speak very loudly to, especially in 2020, summer of 2020, of how important the presence of diversity is. So I'll begin with early involvement. And we really feel that involvement of board members early in the process of investigation and kind of discussion of cases is important. You've had a model where you've had the secretary and supervising member who have done that role for, I mean, that has been your model. And I think it's not that it hasn't worked well, but we feel that best practice for boards is to have more people involved earlier in this process. And there are many ways you can do that. We did give you some suggestions, or we gave you some examples of some other state boards and committee structure that they might have to have more people involved earlier in the investigative process. But then we also looked at your system, and we thought, staying with your secretary and supervising member, that you could add a third person to that group. We would highly and strongly recommend that one of those three people be a public member. And then in order to really increase involvement and opportunity and experience and exposure to the investigative process, we would recommend that those positions be rotated, or that there be term limits on those positions over time, so that more of you would get that opportunity. And I say that because I think, having sat on a board, we had a system where we each of us was on an investigative committee that was divided up geographically. And those that we were able to sit and adjudicate on cases that were not from our investigative committee. But I think when you are present for the investigation discussions, you learn much more about the breadth of misconduct. You learn much more about patient complaints. And I think you're better able to adjudicate when you do look at cases for which you were not involved in investigation. So we all thought that that represented best practice and that you would all gain tremendously from more involvement of more people earlier in the process. So there was another opportunity we thought for more involvement, and some of these, one of these was on the licensing committee. Currently, your licensing questions or reviews are really run through the secretary and supervising member, but we thought that that could easily be evaluated by a separate committee. Again, giving more opportunity to additional board members to learn more about the licensing and disciplinary process. Having that ultimately that additional perspective, that additional knowledge and experience would be helpful in making your board stronger. I'm going to skip down to we have a couple of other ways that we thought board members could be more involved earlier. And one was through another one besides on the investigative role was in quality assurance. You have had a couple of programs in the past that are no longer running, but could be restarted in some way, should you choose. And those were both the post-mortem review of cases, as well as the quality intervention program. And the details we have on those are in the report, and I think probably many of you are familiar with those programs. But again, having additional people on the board involved in looking at those cases in different ways could give you a lot more perspective for overall patient complaints or public complaints, as well as misconduct. And then board training, which I actually think you do a very good job, but again, is a way to educate and give more exposure to the board members. It's a bit, in some ways it's more passive, it's not an active role, but it's still very important. You've done an excellent job in training. And I commend you. You've promoted the trauma-informed investigation training, not just for your staff, but for your board members. And I know that you are going to be involved in strategic planning for the board, which is also something we agree with and commend you for. Providing regular feedback to the board. I know you do that to some degree, and we commend that and recommend that. Regular feedback on current complaints, as well as feedback from other committees, including a post-mortem review committee, if you were to reinstate that committee. And then finally, I'm going to step back and talk a little bit about the public voice, because as I said, it's really an important voice on state medical boards, and best practice is really moving to more public members and to really recognizing the value and the importance of an active role for public members on state medical boards. I might, when I think back to the work from the Physician Sexual Misconduct Committee, we had a couple of survivors of sexual misconduct present to us as a committee, and it was extremely powerful. I can tell you that they were inclined to think that state medical boards are there to protect physicians, and I think that really just speaks volumes to how important it is to have public non-physician members on state boards, and how important it is for those people to be involved in decisions. And I think especially decisions to close cases, and in particular to close cases on sexual misconduct. So for us, having a public member present on that investigative committee is really a mark of best practice, and something that, as I said, is especially significant and important for closing any case of sexual misconduct. That you have a couple of different pathways through which those are currently closed, but I think that having a public member present and hearing the story and contributing to the decisions is really critical for the public trust to be there in the decisions that the Ohio board is making. And then finally, I'll end with diversity. Diversity on all boards in all settings is important. And diversity for a medical board involves a lot of things. It involves, public members and licensee members. It involves gender. It involves specialty type and geographic distribution, as well as race and culture. So certainly you have many of those aspects of diversity, but it's something that we continue to strive for, all of us, in order to really ensure balance in our discussions, ensure fair representation, and have more perspectives at the table when we're making decisions. I know that you are all appointed by the governor, so it is really up to that person and the people involved in those appointments to promote diversity. But one way in which that can be done is through term limits. I know currently you do not have any term limits. And I think it is best practice across the country. Most boards have some degree of term limits. So while we certainly appreciate experience on the boards, there is maybe a point at which it's time for people to give other folks a chance. It also allows more people, more licensees, more public people in the state to have an opportunity to be a part of this and to understand and to really promote the strength of the board within your state. So I'm happy to answer any questions, but I think I'll stop there for now. So Stephanie, again, thank you so much, and thank you to all of you.
Great. Thank you all. Thank you for the overview of the work that you all put into this. And I think the best way to proceed maybe is if we just, I know there are board members with questions, and if maybe you just raise your hand just like we do during any other time in the board meeting. And I'm happy to maybe, or Dr. Schottenstein, if you would rather call on people for questions.
My pleasure. You're doing great. But I guess I have a question.
Go ahead. Start us off.
And thank you so much. One of the things you mentioned was that we as a board should settle more. I think that that's certainly a worthy goal. What's the thing that gets in the way of our settling more cases?
I think I made that recommendation, or I at least presented that recommendation, because really the whole group has been involved in all the recommendations. Well, first of all, looking at you have a lot of cases that go to hearing, and part of what we were hearing is that everybody likes to be successful, and they want to have a case that's completely, for lack of better terms, locked and loaded, ready to go. And sometimes it can get in the way, attorneys, and I know that it isn't easy, but something like 43 hearings a year or something like, even in the 30s, is really very high. If we went to hearing, we probably would have 3 or 4 a year. Most of our cases would settle because, frankly, we either have the evidence or we don't. It may not be perfect, but we either have the evidence or we don't. So perhaps some training for the attorneys, and I don't know if it's the Attorney General's office or your enforcement attorneys, but maybe both would need to have some more training on how to negotiate these cases. And I think it will bring them to faster resolution.
Thank you so much.
Great, thanks. Let's see, other questions from anyone? Yes, Bob.
Hi, Kathleen, I think it's back to you, but because you mentioned it, medical director. Great concept. They're expensive and hard to get. So how do you reconcile that, especially in the budgetary times, especially now with COVID, et cetera?
Yes, and you raised some great points, and you're so true. It's not always easy to find the right person. I did find that challenging in my experience, but I'll have to say I was rewarded and got some fabulous people. And one was a former chair of the board, ended up coming back later and serving as the medical director for quite a few years. And these recommendations that we've made, they're interrelated. And so the assumption going forward with that medical director recommendation is that you would have that investigative committee. And that's an opportunity then for that medical director to say, if you had educational recommendations for the licensee who is being investigated, the medical director could be the one who sends that letter to the licensee. So it's a face for the board that I think is invaluable. I think you will also save some money in your expert reviews, because I know you're paying by the hour, or at least I assume that you are paying by the hour, and that can run up pretty high on it. So I think the money spent is well worth it. It is a well-paid job, at least in state service. Stephanie has her personnel experience. The medical director made a lot more money than I did, and that was just fine with me, because we had someone who was board certified, experienced clinically, had done some peer review out in the community, and really they were able to attract some expert reviewers also based on having that medical face. And I think you'll save some money also in terms of malpractice reviews. That the medical director did all the malpractice reviews for us.
Okay, great. Thank you.
Thanks.
Other questions that we have?
Dr. Feibel's hand is up.
Yes, Dr. Feibel. Oh, you're on mute, Dr. Feibel.
Sorry. I'm curious from a best practices standpoint, and I know it varies by case, but if you were saying based on the other boards you've looked at, what do you think the time frame is from complaint till a site is issued is best practices?
I'm happy to answer. We actually ended up having a statute put in place. I think it was the Medical Association that brought that bill and said we had to get a case to the board in 120 days. Well, that isn't always possible. So what we did is said, and this is our interpretation of the statute, forgive me, Ms. Montgomery, but we said 120 days is when we got it to the investigative committee. So that was our goal, and then any cases that went beyond that, we were listed them for the board members at the investigative committee and would, if they asked, explain about why a case was taking extra time. But I think it's very hard to set one because you have some cases that can be extremely complex with multiple patients involving care that can go, frankly, more than a year. I mean, that's not uncommon. At the same time, you want to be able to have an emergency suspension if you need it. If you have a couple of patients and you've interviewed them and you think they're reliable and you have a sexual misconduct case, you want to be able to take that licensee out of practice as rapidly as possible. So there's a real range there.
That was my other question, actually, was you kind of answered my other question with this a little bit, but summary suspension, I think I wanted to know what best practice was with that as well, because we seem to have a hard time doing a summary suspension because we're worried that we don't have enough information to actually suspend that physician, and by doing that, we might lose the case. Do you have any thoughts on that?
I do, actually, because one of the things we did was we set up a settlement process for that as well, where we would tell the physician or other licensee, this is the evidence we have going forward. And we're prepared at this point to take it to the board for an emergency suspension. However, if you wish, you can sign a consent agreement taking yourself out of practice right now. We won't have any facts of the case in that consent agreement because it's public. So there's an incentive to the licensee my name isn't going to be out there with the dirty facts. It just says I'm going out of practice until this case is resolved. And frankly, most of the time we were able to do that instead of having to go to an emergency suspension. Now, you do have to have enough evidence that if your bluff was called, you have to be able to go to a hearing. So we were careful in those cases, but we were able to resolve them pretty expeditiously that way.
I would I would add that Vermont did that a number of times also, where it was a voluntary cessation of practice while an investigation was ongoing, and that seemed to be, Kathleen, you're right, it kept less information out there for the licensee, but it did remove that person from practice in terms of public protection. I will add, it's interesting, you know, the Atlanta Journal-Constitution, when they wrote their expose on physician sexual misconduct, they were somewhat critical about boards not doing summary suspensions in cases, but instead allowing a voluntary cessation of practice, which is, and I remember talking to people and saying, you know, the board just wants the person out of practice and they want to do that the most expeditious way. And we all often didn't have really the resources to kind of go on and on with something. If we could get someone not to practice, that was by a voluntary agreement, that was fine. But there will always be some criticism along the way. But I think at the end of the day, just knowing you've protected the public was the most important.
This is Brian. Could I? Yeah, I'm sorry.
Go ahead, Brian.
Yeah, I just wanted to chime in on both of those questions. They're very good questions. Regarding the best practices on how long a case should take before something is resolved, a cite is issued, whatever. My experience is that, picking up on what Kathleen said, it's not so much how long it takes as it is that there is some process of review to ensure that the case is not stagnant. So what I would recommend as a best practice is not setting an arbitrary time, 6 months, 12 months, 18 months. I wouldn't recommend setting an arbitrary time because cases are so different in terms of evidence, the facts, witness availability. But I would recommend a structured process of being able of doing a case review after a period of time, and then thereafter periodically to see what's going on. I think your situation to me presents some unique challenges because there's a handoff from the board to the Attorney General's office. And I think the Attorney General's office, if possible, should be involved in those discussions so that it's clear that the case isn't being held up by one person who's trying to build a case when the person who's going to actually try the case may think you're already there. So I think just a formalized process of case review would be helpful. And then on the summary suspension, we don't do a lot of them. We do allow opportunities for doctors to surrender or go inactive. We have something called a non-practice agreement where we don't make findings, but the doctor agrees that he or she will not practice pending resolution of the investigation or the case. So we don't have to pull that very often. It is a high bar. I would just, my direction to my attorneys is we should never not take a case because we're afraid of losing. As long as we believe we've got sufficient evidence and that we are doing our job to protect the public, I'm okay with losing. And we frequently say, if a judge wants to make a decision that a doctor is not a threat to his constituents, a judge can do that. But if we believe we have met our ethical obligation and have an evidentiary basis, we will never be afraid to lose. And I'm not saying anybody there is afraid to lose, but I caution anyone who uses that as a standard whenever I'm talking to audiences.
Well, if nobody's going to call on us, I think I'll just jump in. First of all, I want to thank the board, the folks that have done this report. In many ways, I agree with what you've done in such a thorough job. I do think that many of the issues that you've identified, as soon as Stephanie came on board, she's already at that. You know, if you can't name it and you can't count it, you can't manage it. She's already in the process of doing that and breaking down silos and doing a lot of the things which you have recommended. She even before your report was done, has jumped in with both feet. And once she gets all of her staff in the right places, I don't have any doubt that, because they're really strong staff here, just that this process will go forward. I do think that what you're really describing, in my experience, tells me what you want is somebody who's got a more prosecutorial, that the process is more prosecutorial, meaning you know, you're in the back of your mind, like in Ohio, you have a time frame that because of witnesses, because of evidence, because of the statute itself, you have to move with some appropriate speed. That you do have people not afraid to know that you don't have to have 100% case. Sometimes you can't, but if you have enough to meet the burden, you should go forward. And that's the mentality. You proceed, and the court can decide whether you're wrong. And occasionally we're going to be wrong. That's okay. I do think, though, when you take a look at your recommendations with regard to our supervising member and our secretary, you know, it troubles me, always troubled me, that we've got two wonderful physicians who are moot on whose judgment the board as a whole, at a board meeting, we'd love to have. The way we're structured, they can't be. So if you term limited them under the way we're structured now, they would essentially be not able to vote on cases for years because they've been involved in the investigation. So your recommendation is a good recommendation, but in the current structure just wouldn't work because we would virtually taking two good players off the field and benching them because they couldn't comment and they would have to. So if you were even thinking of restructuring, would have to go to more of a, how do you divide up the caseload so you rotate board members for a certain number. And again, then the worry, a certain kind of cases or regional cases, and that then you worry about consistency and process getting in the way with appropriate timeliness. So that's just a comment I have on that. And we're obviously looking at a case management system. I think your suggestion that we consider hiring hearing officers is a really legitimate one to consider. I think you're also, what strikes me more than anything here is I think we can build in some accountability, more public accountability, depending upon how we structure ourselves or if we continue. But what really strikes me is that we have a lot of business, the board has a lot of business, and making our committees not quite so, we're efficient, but unfortunately, I think sometimes our efficiency gets in the way with some you know, we only have a limited amount of time. So perhaps expanding, you know, our engagement would get our board members involved more. timing is probably in our backlog is a big problem, and I think we're addressing that. And our expert reviewers is sort of a mess, in personal opinion. So because we're not doing it in a timely fashion, I think we've already engaged our investigators, and we'll continue to engage. Stephanie's done a remarkable job there. I couldn't agree more that keeping our investigators engaged from beginning to end bring some accountability to our board members, our docs who may not understand some of the criminal problems or may not have that experience. And at the same time, they're engaged, they learn, and they're invested, and it helps in the culture and camaraderie. I think you hit on a great point on settlement negotiations. Question would be, do those settlement negotiations, where do they occur? If they're not in the court, I think technically they can occur in the board. And so the training on how to be engaged in a discussion about not taking everything to a hearing, I think is fundamental to helping us break down a backlog, let alone sort of, those cases that we can't, if we have to hire folks to get rid of our backlog, do so. So all in all, I think you've really done a wonderful job of evaluating, and that we just have to take a look at our structure, and if the structure is where we want to keep it, then how do we accommodate more engagement?
Could I just interject? I might just say, we talked a lot about the supervising secretary and supervising member model and how to involve more people. The other thing, and there are a couple examples of the report of totally different models, and I know that Mark and John would be happy to provide even more examples. So you might just sit down and look at a lot of different things and make a decision kind of what's best for you in order, looking at a lot of different opportunities, but nothing's perfect, obviously. And there you have to kind of be able to kind of take the pros and the cons of any one system, but I appreciate the, how long do most of your cases take to get through the system?
Yeah, that's a good question, Dr. King. I don't know that we have an average that we've taken, that we quantify that time. We're really getting into the transparency piece right now and keeping that information out on our public website and sharing that with the board. But I don't know that we have a good estimate of what that time looks like. And then kind of by category, how long it takes maybe to get to site, or then to settle, or then to a hearing, and then how long through the hearing. I think, suffice it to say, and I think staff would share in this thought, that we would like to be moving them along faster. Yeah, great. I know, Dr. Bechtel, you've had a question for a while there.
I just wanted to comment. One of my biggest concerns, having been a previous secretary, supervising member, evaluating a lot of these cases over the years, is implicit bias. And that is one of my biggest concerns in sexual misconduct, because I think your recommendation of having a non-physician community member involved in the final decision on whether sexual misconduct has occurred is really important, because a lot of times you'll have two physicians and you'll have a victim, a possible victim, and a physician, no witnesses. It's he said versus she said, and that's a difficult situation. You really want to make sure that you make the correct decision. I think having a non-physician involved in that process is really valuable. I'm also concerned with implicit bias, with physicians citing in favor of physicians in that situation, also with victims advocates, and whether or not you've ever experienced situations in which they're involved in the final decision-making process, and they may, favor and side of the victim because of implicit bias they may have too. And I didn't know if you had any comments on
that. I'm happy to address that.
Yeah.
Dr. King, if you have comments,
Go
please.
Go ahead, Brian. Yep, that's fine.
I'll address the last question first regarding victim advocates, victim witness coordinators. There's a lot of names you can use. I've got 26 years experience in the military. That was my really my first. That was my introduction to victim advocates several years ago, more than several now. And I use that model and the model from one of our district attorney's offices, setting up our what we call victim witness coordinator position. So in terms of implicit bias, I think a lot of that goes to how you structure your program and what your expectations are for your victim advocate. We very specifically in North Carolina do not call our person in that role a victim advocate. They actually don't advocate. We call them a victim witness coordinator, and their only job is to help the victim through the process, explain the process, and really be a statewide coordinator for getting the victim help if they need it. My guidance to my victim coordinator is you're in the unique position of not having to question their believability, their story. The fact is, if they are traumatized, that's all you have to concern yourself with. You don't have to concern yourself with the facts, and we sequester them from the investigation and from the prosecutor. So I think if you have your victim coordinator advocate in a position where they are advocating for the victim, well, they're going to do that. So I wouldn't call it implicit bias. I would say that's the bias created by the job. I mean, their job title is victim advocate. So the expectation set pretty early is that they will advocate for the victim.
Yeah, that's a very powerful role.
The other thing I would just, I'm sorry, go ahead.
Well, I think that's a very powerful and important role in that process. I think it's a really critical part in moving the process forward.
Yeah, and then the only other thing I would say is that
You would say, but we can't hear it, right?
I think we lost Brian.
Involved and other, and I would just I would close with saying that in my experience, where the only witnesses are the victim and the perpetrator, often called he said, she said, but it could be he said, or she said, she said, that that's where it's especially critical to get your investigators involved, because if you're just reviewing the written statements, the issue is the credibility of the witnesses.
Right.
Because if you don't know them, and hopefully you don't, or you'd be recused, and all you're using is the written statement, you have no way of determining who's telling the truth and who isn't. And that's when it's especially critical that you talk to the investigators and that you have potentially the Attorney General's office, who will be prosecuting the case, involved, and that multiple people are talking to the witness, because ultimately what it will come down to is witness credibility. They are hard cases, but they are not impossible cases, and I've taken a number of those to trial. Thank you.
Thank you.
Stephanie, I think implicit bias is really important, and on every level in the board. Kathleen hasn't said anything, but I think her board has had implicit bias training. So even on every point along the way, it's hard because it's part of all of us. But I think as much as we can do to increase diversity, to have the public members present, at least in terms of the public trust, we're doing as much as we can. which is an important point. And Kathleen, maybe you would, I don't know what the Oregon board did, but you had a program for implicit bias education, I believe.
We did have that. We did have that, and they are continuing to do that. The other thing I wanted to mention is in the first 2 months when I took my job, we had an OBGYN who was accused of violating 150 patients. This was in my first 2 months. And what the board offered going forward from that point was the opportunity for each of the victims to come and tell the board their story. And we continued that throughout the time that I was at the board. Many times the victims did not want to take advantage of that, but sometimes they did. As Brian mentioned, this idea of assessing credibility is essential. And we didn't just do that in sexual misconduct cases. We did it where there was any credibility type of issue. We offered the complainant or alleged victim to be able to come in and tell their story so that the board could see and have that opportunity. Now, that may not be a route you want to go, but as Brian mentioned, you do have your investigators who can be your eyes and ears out in the field.
Thanks. Betty, yes. Betty?
Just a brief question. And it's off subject here a bit, but I've got, I think, are all of you are with FSMB, FMSB, whatever it is. I always get that number. I have a bias here. I would hope that you folks take a look at creating a database so that all 50 states, when we have a discipline, that it is immediately reported. So we're not waiting sometimes a year or longer, or waiting several years until in our instance, somebody reapplies to get their medical license updated. It just seems to me in this day and age, we need, it's not rocket science, the requirement that all of these boards must report at the point of discipline where the docs are, what's happened with their licensees. So we can take a timely action rather than be in a situation where we were or have been in any number of cases recently, where we're years before we're giving doing appropriate discipline or inappropriate discipline, if you will. So just do you have any sense of, is there a reason why while you're doing best practices for us that it doesn't appear that the national board hasn't got that?
Can I respond?
Yeah, go ahead.
I'm sorry, go ahead, Mark.
Well, I was just going to respond that we do actually have a disciplinary alert service where we will disseminate alerts to all of our member boards across the U.S. and actually some international jurisdictions as well. When the alert isn't necessarily immediate, it's often because we haven't received the notification from boards yet. So we have a variety of frequencies of reporting from our member boards. Some of them report to us daily on board actions. Others report beyond every month. And so I think it'd be rare for it to take a year before we'd report out, but we report out disciplinary alerts as soon as we can from our end. And we can offline share more information with the Ohio board about our.
Yeah, this is off subject, but I'm not sure I agree with you.
I think Ms. Montgomery may have frozen there.
About your assessment about that, and maybe been here longer. Could, frankly, I'm not sure why, if you have a membership, it's not part of your membership requirements. So I don't know that you want to do that because you want to have as many boards as part of your association, but it's just, I think, an elementary best practice.
Dr. Feibel.
Yeah, I have one more question. I appreciate that you want to get everyone involved in the secretary supervising member role, and I think it's very important for that. Our current structure is going to be very hard to do that. So I was wondering if there are any models out there where you can have a rotating secretary and supervising member or 3 people, and they can see how the sausage is made, but still be the finder of fact. Because we all can be objective in the end, and ultimately we all see the testimony in the end when we're trying the case. So are there any models where you don't have to be excluded as the one who helped the back scenes investigate this? Because I think that would really open up our system and really make it a much more fruitful experience for all, and allow everyone to be involved in that process and still have enough people to adjudicate the case.
Yeah.
Well, this is Brian. I'll chime in, and one of the difficulties of assessing boards and for the FSMB is that so much of what boards do is dependent on their own individual state statutory requirements. I can just tell you that in North Carolina, as a model, we have a disciplinary committee. That disciplinary committee is a little bit more than a third of the board, and they review all the investigations. They make recommendations to the full board, and they're not excluded from sitting as fact finders and ultimately finders of fact and discipline. So that's allowed in North Carolina. There's no statutory provision against it. There's no case law that prohibits it. In fact, the case law says we can do that. I'm not aware of any federal prohibition. So, I'm obviously not an Ohio lawyer. You have several of them. So I would just ask, if you haven't done it recently, to ensure that what you're doing is in fact what's required by law, and that you are not restraining yourselves unnecessarily. So I understand that the secretary and supervising member statutorily have to have a role. I didn't see in your statute that other members are prohibited, and there's very likely case law in Ohio that deals with that I'm not familiar with. But I would just ensure that you're making available all the options consistent with what Ohio state law statutorily and case law allows.
Well, I would hope that we would be able to, since we're revamping the system, that we'd be able to lobby the legislature to say, hey, this is how we think we best set up the medical board to be more effective in the future. And with your recommendations, I think we have a lot of wind behind our sails in that recommendation. And I would vote to try to turn the system on its head a little bit and try to get rid of the prohibition against the person helping to investigate not being able to be part of the finder of fact. I think we all could be objective and independent in our thinking, no different than a judge can in their thinking. And so I'm hopeful that we can really make some substantial changes to really make the system a lot better. But it's going to take a heavy lift on our part, and it may take you guys help the FSMB helping us in the legislature if the time comes to it.
Brian, can I have a clarifying comment or question to the way you set it up? Because are you telling me that your disciplinary committee gets everything, prejudicial, everything just goes in and they make a decision? Because that's what it sounds like. And that's kind of the problem we're getting here is we're trying to keep it objective for the decision makers in calling out the data. So how does that work?
So it's in North Carolina. We have a disciplinary committee. They review all investigations. They review our malpractice cases. They review our complaints. Staff makes recommendations. We discuss them at a meeting, and then yes, if a case has to go to hearing, they can sit on the panel. And I understand that looking from the outside, it could seem odd. I can just tell you, I previously worked at the North Carolina Attorney General's office. It's a model that's used a lot in North Carolina, and I'm not saying it's the way. I'm just saying it is a way. and it in the vast majority of cases, it has seemed it has seemed to work. It certainly has not been challenged with the frequency you might think, and I think some of that is just the volume of cases that our board receives. Makes it very difficult for them to remember with any specificity when a case comes to hearing a year later. I think it just makes it very difficult to remember the facts. Secondly, we do a fair amount of board training, and they realize what they're making is a probable cause determination. They're not making a final determination. They're making a determination based on the evidence before them that there is probable cause that the doctor has committed a violation of the Medical Practice Act. And the board members do a good job of considering the evidence and making a determination. If the doctor believes that the board's decision is not supported by the evidence or that it was arbitrary and capricious, that is a grounds for appeal to a Superior Court judge who will review the record of the hearing and make a decision. In my 18 years at the board, I think we had maybe one when I first joined. We had one that was maybe sent back on appeal. But I think the proof is kind of in the pudding. So it's different. I get it. But if you're looking for models on the opposite end of the spectrum, that is one model.
Well, Brian, what you're saying, however, is different than what we're doing. What Dr. Rothermel and Dr. Safran are doing are actually engaged in working with the investigators and approving certain lines of inquiry or methods of inquiry or the like. So they're not sitting as a, if you will, at a preliminary hearing stage as a judge saying, okay, what have you got? And is there probable cause to go forward? They're actually engaged with the process of gathering the evidence to present. And that's the distinction between, I think, what you're describing and what we have happening in Ohio. And clarify that for me if I'm wrong.
No, the way Ohio is structured is certainly different than what I've described. And again, I'm not advocating that we have in North Carolina the best model or even a top 20 model. It's just a model. I think based on the review team's review and our recommendations, are again, I think there's a lot of ways to do it, and we recommend greater involvement. In terms of the level of involvement, again, I would ask that you seriously consider what is actually required by law versus what is the way you've always done it.
Mm-hmm. But what you're doing though is your disciplinary committee advising your investigators what to do or making decisions pre-presentation to the disciplinary committee regarding the evidence? Not at all. Okay, so we do have a distinction. One is completely just a preliminary before the board meeting in terms of the value of the evidence. The other, what we have, is a gathering of information to create the evidence or to make sure the evidence is gathered. You don't want to create the evidence. Gathered for the board presentations. Those are two different models, yeah, entirely different.
Yes, ma'am. And again, our recommendation is that you look at that model, and I understand it's what you do and what you have done. Our recommendation is that you look at that model and in particular, look at possible changes to that model, not only the number of people involved, but the level of their involvement. And I think that's where it's important to determine what is actually required by Ohio law versus what is the way you've done it.
So in Oregon, we did sort of a middle process. We had a monthly investigative committee meeting comprised of 5 or 6 members out of a 13-member board. And that group met every month for a full day. And every licensee prior to being disciplined had an opportunity to be heard by that investigative committee. So they would come in and be interviewed by the board, and it wasn't a choice of the licensee. They would be invited, but they would have to come in and be interviewed by the board. If a board member interviewed the licensee at the investigative committee stage, they had to recuse themselves at the final disciplinary action. Again, that was in statute, and Oregon statute is different than Ohio statute. But it really seemed to work because, for one thing, the board was able to assess the credibility of that licensee and hear in their own words what the circumstances of the individual case was. And at the same time, we did have a very fair process at the end of the day.
Great.
If you had 5 or 6 board members who participated in that manner, and then they could not vote when it finally came to the board for final adjudication, how did you manage to, achieve a, quorum of votes, right? You don't have that many members left to vote.
So only if the physician or public member interviewed that licensee. If they were the primary interviewer, they were recused. And in fact, if it was a public member who handled that case, the statute provided that the public member could still be part of the decision-making process at the end. And again, that's very specific legislation. I mean, it's a very specific law in Oregon that was worked out between us and the Medical Association.
Well, one way we could potentially, because I like the idea of having public member input on the closing of cases, we could conceivably, in a minimally disruptive way, continue with our secretary supervising member model and rotate our public members through the decision making to close cases, and that way have those public members weigh in. In our state, the impact that would have would be that, because we need 6 yes votes for a finding, we would then be, at 6 out of 9 instead of 6 out of 10. But, that's conceivably doable at the same time. But just in terms of talking about the pro and the con of these different things, that would be the potential downside. And, I was also thinking along the lines of what Dr. Feibel was said in terms of how do we get more board member exposure to, to these matters. There are times when the secretary and supervising member have to recuse themselves. And I've talked to Stephanie actually about this along those lines before. Conceivably what we could do is rotate, our board members through the position of acting supervising member or acting secretary and give people experience that way, right? That would potentially be a way of doing it. I think that sometimes we just sort of get used to picking the people that we pick, like Dr. Bechtel has been acting supervising member a lot because he has a lot of experience with that. For whatever reason, I've done it many times as well. But conceivably, we could, take turns and just sort of rotate different board members through, because I'm guessing there are some board members who've never done it. And it could be, good experience in that regard.
I do think it's really important to have a community member involved in the final decision of sexual misconduct cases, rather than just strictly the supervising member and secretary. I think a community member, is really important.
It's optically, helpful to have that.
Mm-hmm. I would like to propose that, obviously we're going to discuss this at our retreat and everything, but I would like us to think globally after hearing this report that how can we be disruptive, and I mean disruptive in a positive way, not a negative way, to the system, and really think outside the box about not what we've done in the past, but how can we do something different? And again, I think we will have potentially the legislature's ear based on this Strauss investigation issue to say, hey, we didn't do it. We don't think it was right before. We have a new method that we think works in other places. Will you be behind us on this? And really think outside the box about ways we can we can make changes. There's nothing that says that the legislature won't do this for us, won't make changes for us. And so we might be able to rewrite a little of the legislation ultimately to allow us to be like one of these other boards that is working potentially more effectively if we like that system. So I would challenge the board, our board, to be a little more disruptive in our thought process about how we can really think outside the box and make changes.
I'm glad
Kathleen,
that, you know,
Kathleen,
forgive me,
can I ask you a question? How many complaints do you get a year in Oregon?
1,000.
How many do we get, Stephanie, in a year in Ohio?
Between 6,000 and 7,000, I think.
Okay, so we have to think about the scale.
Scalability.
And in Vermont, I suspect it's a lot smaller. So some of the personal stuff that you can do in a smaller state, population-wise, we can't conceivably do and be timely. So I think we have to take all of that into consideration.
Right.
But
I
really,
yeah, I think that Mark and John gave some examples in the report of Colorado and Arizona. I don't know if those were chosen because of size, comparable size, Mark, or just varying structure.
They were chosen because of varying structure. They're not comparable size, especially
I was
Arizona.
going to say they're not comparable size.
Okay.
You'd have to go to Florida,
Yeah.
Texas,
California.
maybe
California.
Washington, Illinois, New York.
Yeah.
well, I just would want to make the point, if I may, respectfully, I don't think our system's broken. In other words, I don't know that we need to sort of jump to, upend our entire way of doing things. I think that the way we do things has served us very well over a long period of time. So always, glad to, be apprised of other alternatives and weigh those. But I also, feel like our system essentially works. And I also want to keep that in mind as we proceed as well. And I had one more question, if you'd be so kind. Just back to, when we were having a conversation about one of the methods you all would use to settle a case, which is to say you would keep the particulars of the case out of the settlement agreement. And that would essentially allow the doctor to save face, right? Which is to say, take himself out of practice, but without any details of the case being released. And again, on the lines of there being pro and con to everything, inherent in that option is a lack of transparency, right? And so does that ever feel like a cause for concern in terms of not sharing information with the public that they might otherwise need?
I want to clarify that I was talking about at the outset where you have sufficient evidence where you might go to an emergency suspension. If you were to go to an emergency suspension, you would have to put all that detail into that document. And I'm talking about at that juncture, not as a final resolution. I'm talking about for the emergency suspension, which is generally not the end of the case.
Okay, thank you for clarifying.
And I would agree with Kathleen. Where I saw that done in Vermont, it was while an investigation was ongoing, during the investigation, not a final outcome.
Okay, well, we are running sort of to the end on time. Are there any board members that have any final questions? I just have one, but I'll wait in case anybody else has one. Okay, no? Okay, great. So I was wondering, maybe just to close it out, and all three of you probably have thoughts on this, but one of the things that we've been really talking about a lot, and I think this, gets to some of Dr. Feibel's idea too, about what do we do with this next steps. We've been hearing a lot from you about the increased value of having that public voice, right? And we see that throughout the report. And so as I was thinking about this, and I'm just, sort of being selfish as I think through our crafting our remedies and taking anything to the legislature, do we have any sort of national data, or is there any other data that comes from any of the other boards that really kind of gets to outcomes when there's more public involvement, right? So are we seeing states adopt that more public approach and then getting better outcomes from that? Or do states that have that public involvement do we have something that we can point to say this is our why, right? This is why we would want to include that public piece.
Mark, I know, or Stephanie, Mark and John might have the exact numbers on public members on all boards, but I do know that we can get you a publication. John, or Dave Johnson wrote a paper on value of public members, and I can't recall all the data in that, but we can certainly get you that. I don't know if John or Mark, if you're more familiar with that off the top of your heads.
I can't reference data off the top of my head about actual regulatory outcomes, but we have been doing a lot of work in the area of public membership on medical boards. And so as Dr. King mentioned, we do have information we can share. So we'll make a note to bring that back to you and see what we can provide in terms of outcomes.
That's great. I think that sort of is the underlying theme that we see with a lot of these requests. So I think that would be really helpful. And then, of course, as we're going through things and having more discussion, other themes that we see where we come back to you all, and we know that you've done the research, so we won't reinvent the wheel on our end. We appreciate that. Okay, well, if we don't have any further questions, I think we're ready to wrap up right now. Again, thank you all so much for all of the time that you put into this report. I know you put many hours into it, and after 8-hour days of interviewing all of us, then you all met as teams, and you were meeting as a team in the evening hours, and probably on different coasts. So I can only imagine how complicated that got. So we really appreciate all of your time and insight. And unlucky for you, we sort of consider this the start of the dialogue with all of you as we look to you for some expertise. So thank you.
Thank you.
Thank you.
Thank you so much.
Thank you.
Thank you very much.
Thank you.
Bye-bye now.
Bye. Thank you.
Thank you.
All right, Dr. Schottenstein, we'll need a motion to adjourn from the main board meeting.
Wow. Okay. That concludes, yes, August 12, 2020. Great. Thank you very kindly. All in favor? Aye.
Aye.
Bye.
Aye. All opposed? Okay. The time is 3:29 p.m. and we're adjourned. Thanks for everything, everybody.
Thanks, everyone.
Have a good month.
All